Good afternoon and welcome to our IP lecture series. Very pleased to have you with us. You know, it's so apt to be talking about colors on a dreary, gray day like this. And it's such a delight to have with us Professor Deborah Gerhardt from University of North Carolina, Chapel Hill. And she's done a fantastic study on colors and trademarks, and she's here to share some of the surprising and perhaps non-intuitive insights with us today. John Marshall is really proud of producing practice-ready graduates, but we're also serious and committed to good scholarship. And so that's why we have this IP lecture series, but I'm also pleased to announce that this year we are launching a IP Scholars Roundtable in the fall to promote precisely the kind of rigorous, useful and interesting scholarship on cutting-edge issues that the Academy is and should be known for. So stay tuned for more details. Now, students are at the center of what we do. We are proud to give them front row access to the leading thinkers and newsmakers in the IP world. We're very pleased to have with us Luke Chamberlain and Adam Prof, who are both serving on the review of IP law, really one of our best-known exports in John Marshall's IP scene. And if you are ever thinking of writing something in IP, they get it done fast. It's rigorously site-checked and very efficient, very professional. So please think with publishing with them. And in a moment, I'm going to introduce two students who will be here to introduce Professor Gerhardt, Lamar Allen, and Jordan Gillespie. So please join me in welcoming Lamar and Jordan. A couple of housekeeping things. One is there is a sign-up sheet that's going around. If you are not on our mailing list, you would like to get news about our events, please put your name and email address. Will add you to the list. Also, there's going to be a reception afterwards. Coffee and cookies behind. Please stay back and interact with our speaker. I'll be back again for the Q&A after the lecture.
I'm looking forward to the refreshments. Good afternoon. My name is Lamar Allen, and I'm a 3L at John Marshall.
And I'm Jordan Gillespie, and I'm a 2L at John Marshall. We're students of Professor Lim's Intellectual Property Survey class. Today we're pleased to welcome Professor Deborah Gerhardt, a very special guest from the University of North Carolina. Professor Gerhardt is an associate professor of law at the University of North Carolina School of Law. She teaches arts entrepreneurship, art law, copyright law, trademark law, contracts, and a writing seminar on intellectual property strategies and transactions. Professor Gerhardt's specialty is at the intersection of law and creativity. She has published articles in trademark, copyright, and art law in outlets including Landslide Magazine, Loyola Consumer Law Review, and the Berkeley Technology Law Journal. In 2008, she was awarded a grant from the Mellon Foundation to support research clarifying whether art and historical documents are protected by copyright in the public domain. And in 2018, she was awarded UNC's Distinguished Teaching Award for post-baccalaureate instruction. In addition, she secured a UNC slot in USPTO's pilot clinical program and led an effort to launch Carolina's Intellectual Property Clinic, where she has taught students practical skills while providing pro bono counsel to artists, musicians, and small businesses.
Prior to joining the faculty at UNC, Professor Gerhardt clerked for the Honorable John A. Meadows. What is it? John M. Meadows, sorry about that. On the United States District Court for Northern District of Ohio. She practiced at Jones Day in Cleveland, and Hudson and William in Richmond, Virginia. And she was a professor at William and Mary's Law School and associate director of the Intellectual Property Project at the University of Richmond. She earned her bachelor's degree in political science, some do, the Blue Devils, and her JD degree from Case Western School of Law. Today, Professor Gerhardt will be sharing with us her new research that provides contemporary insight into how consumers respond to colors. She will show what her research reveals about one, consumer color preferences, two, color quality associations, and three, whether consumers use colors to find brands when they shop. Further, she will explain how trademark law sort colors signals and the extent to which courts and the USPTO grant businesses the exclusive right to use a color in a particular market. This lecture, Owning Colors, promised to be an interdisciplinary treat that will explore color perceptions, how colors influence market behavior, and a growing trend of claiming colors as IP. With that, I ask that you give your full attention to Professor Gerhardt and help us welcome her to the podium. Professor Gerhardt.
Thank you all so much for coming out today and sharing my enthusiasm for colors. I am so grateful to Professor Gerhardt for inviting me here. This has been just an amazing couple of days, meeting new friends, connecting with old friends, and getting to talk to you all about this project that I'm working on. It is a project that has not been published yet. The data in it we are still working on, so I ask that I know you all have received a draft. I ask that you don't republish the draft if you don't mind, because my co-author and I are still working to finalize it. So if you have any thoughts you have, any comments on the research, any interesting questions you have that the research raises, those can all find their way still into the article. So I'm grateful as I go through the research that we've put together. I'd be grateful if you at any time, if you have a question, don't let it burn in your mind and distract you. Please raise your hand. Feel free to interrupt me with questions. I would love for this to be as much of a conversation as a lecture. Also with us today, via the wonders of technology, is my just amazingly talented co-author, Jon McClanahan, who I'm going to wave to on the computer screen in front of me, in front of Kyle. He is just an administrative guru and an incredible researcher at the University of Minnesota's Law School. And I'm honored, Jon, that you're able to take the time to join us today as well. Thank you. All right, let's turn to this question of owning colors. Well, how does the question strike you? Doesn't it feel like it's an odd thing to own a color? Right? We know that in our system of government in the United States, we honor competition, right? So people should be able to use expressive tools to compete. And generally that is the default in our legal system unless you bump up against an intellectual property right. Well, what kinds of intellectual property rights can one have in something as ubiquitous as color? Yeah, maybe it's not the brightest day in the world, but look around the room, look at all the colors we have. Certainly all of them can be protected by intellectual property. How does our law sort those signals? Well, I put together a slide to give you a sense of some of the ways intellectual property can protect colors. So we have up here some images that represent 3 different ways in which intellectual property can protect colors. So I know we have some patent lawyers in the room, right? Raise your hand if you're a patent lawyer. Awesome. Well, the patent lawyers in the room probably have heard of Vantablack. Vantablack is a patented process for creating the color black. So if you look at the 2 busts here in your top left-hand corner, you'll see one is in bronze and one appears flat. Actually, both of those heads are exactly the same shape, but the one on the right is painted with this patented paint that actually, instead of being flat like the paints that we use, actually is composed of little tubes, and the tubes absorb all the light. So we see all the modeling of the bust on the left because of the way the light moves around the object and is reflected off the object. So we see light where the light hits the object, shadows where the light is shaded, and on the left, but on the right, all the light is absorbed, right? And that inventive technology is protected by patent. And the art world went crazy when this happened, because why should any particular artist have the exclusive right to use the blackest black? But that's what patented technology does. It puts a brand new inventive technology into circulation, but the person with the patent gets a monopoly for a limited period of time, 20 years in the US. Okay, so that's patent, but you know, the beauty of patents is they expire in 20 years. So after that, we all get the recipe for using Vantablack, and any artist who's capable of making this incredibly high-tech paint can make it or use it. Okay, anybody recognize that big field of red on the right? Checking my cheat sheet so I don't get this wrong. All right, the name of this is a painting. The name of it is Who's Afraid of Red, Yellow, and Blue. It is in a museum in Amsterdam, and it is painted by Barnett Newman, and it is part of the school of color field painting, where an artist who uses some sort of expressive information to create a creative work can get copyright protection. In the US, it's life of the artist plus 70 years. Also a long period of time for their, really what looks just like a big red with a little bit of blue and yellow on the edges, right? But copyright protection, there's a very, patented technology is a very high bar of creativity to get protection. Short period of time, but high bar to get it, and a big monopoly. Copyright is a looser monopoly and a very, very long period of time. I see the IP students in the front row nodding their heads. I'm glad you guys are picking up on all that. Okay, now in the bottom are colors that can be protected by trademark. So, everybody recognizes that thing in the middle, right? What is it? Tiffany's blue box, right? And even if the name Tiffany weren't printed on the little ornament that's attached to it, you would all know that. And also, when you give somebody a gift in a Tiffany's box, it does not matter what's inside, because the feeling that is generated when somebody sees that robin's egg blue box with the white ribbon, you have won. You have already done your job at getting a very special gift, right? And this is a color that is, come on in, take a seat. Plenty of room. This is a color this is one of the strongest color marks out there, right? Tiffany's has that specific robin's egg blue registered for all kinds of things, catalog covers, packaging. It is a very strong trademark because when we see the mark, we think of the company Tiffany's, and it evokes very meaningful values of something special, of luxury, of high quality. That's what the best trademarks do. They signal source, but you guys read your definition of trademarks about signaling source, but that's just really the beginning of the story. 4 out of 5 brands fail, and the ones that succeed are the ones that really communicate meaningful values. And to get a trademark in something like a color takes a big investment, and also connecting it with specific values. Now, you can also get a trademark on color for goods and services. Like everybody recognizes the brown truck and the guy in the brown suit on the right? What's that? UPS, right? You see that truck coming, you know it's not a FedEx package, right? You know it's not the US Postal Service. It's chocolate brown, dark chocolate brown, evoking one of the best flavors in the history of the world. And it evokes a very particular source, very particular quality, but different from Tiffany's, right? And they have that color also protected as a trademark. Interesting to think about a color being a trademark for services, not just goods. Okay, and then anybody recognize these on the left? Louboutin, right? Okay, so sometimes you can get a color registered not just for an entire product, but a portion of the product. And here, what is famous about this shoe for those that might not be, huge fashion followers, is that pop of red underneath the shoe, no matter what color the shoe is, or as it turns out, anything except a completely red shoe. But if it's pop of color that's different from the rest of the shoe, that works also as a very strong trademark, signaling very high-end luxury and beautiful, inventive, artistic shoe design. Okay, so here you have some examples of all the different intellectual property regimes that can be used to protect intellectual property ownership rights and colors. Now, John and I, in our research, are focusing on these trademark signals, and one reason we're particularly interested in them is because colors send lots of messages, and trademarks can last forever, right? So when Tiffany sells some baby gifts, when Tiffany's is selling luxury baby gifts and claims monopoly and selling them in baby blue boxes like that, how do you advise a client with a children's store that wants to maybe sell, girls give some pink boxes and boys give some blue boxes, right? This is something that we face as trademark lawyers, and we think that because pastel pink and pastel blue often signal meanings of baby girl and baby boy, for better or worse, right? Should any one company have a monopoly in baby blue for gifts, including luxury baby gifts? So these are some of the questions that are being raised. How does the law decide, right? How does the law decide who gets to have those trademark rights and colors? And how big of an issue is this? Is this an anti-competitive problem in the law, or is this really not that big of a deal? So we'll be thinking about all these questions as we go through. Here is our plan for the next 45 minutes before we get to your questions. First, we're going to really have some fun talking about the different types of signals, color, consent. And John and I felt that we really needed to research the different meanings of colors, because trademark meaning is different from other meaning, right? And if a color is primarily sending expressive meanings that are not trademark related, well, maybe the law should not permit ownership of marks and colors. So we divide up this section into two types of meanings that we perceive as human beings when we look at color. And these have nothing to do with trademarks. One is the embodied meaning. And by embodied meaning, what we're talking about is how physiologically, biologically, do our bodies respond when we see color? How do we see color, and how do we respond to different colors in the color spectrum? And also another whole other field of where lots of people in marketing and psychology and cognitive science study is the referential meaning of color. What kinds of meaningful signals have we learned through our cultural upbringing and our education, our experiences, culturally? To what kinds of meanings do we attribute to colors, not just from a biological reaction, but from what we've learned? All right, and then if consumers are bombarded with so many colors and so many different types of embodied and referential meaning, do consumers perceive colors, can they perceive colors still to have trademark meanings? When we are lawyers and we look at the world, especially trademark lawyers, and we love to look at the world through our trademark box, and really are so excited, as I see you smile, we see trademarks everywhere, right? Well, what about normal consumers who are not obsessed with trademarks, right? Do they perceive colors to signal brand meaning when there's so much other meaning that colors are sending? So John and I had a lot of fun putting together a consumer survey to ask consumers that have nothing to do with the law, and we did a real robust survey to figure out whether colors actually do signal trademark meaning, and I'll show you that data as well. Okay, so once we get a sense of the meanings of colors and whether colors could be perceived as marks, then we're going to talk about what the law does with all that information and whether it is sorting things in a way that we think is working or in a way that we think should be changed. There are barriers to getting trademark rights in colors that don't exist for other types of marks. You have to overcome the functionality hurdle, you have to overcome a secondary meaning hurdle, and you have to show that your mark is not likely to be confused with somebody else's. So we'll see how that is working out in both the trademark registration process and in litigation, both in federal court and the TTAB. And then we'll see how the USPTO is registering colors. Is this happening a lot? Not so much. What does it mean? Okay, so we've got our work cut out for us. Everybody ready to go? Yeah? Okay. Okay. So this is so interesting. I learned so much working on this project about how we perceive color. So color is made of light. So when we see white, it is, you know how when you look at white light through a prism and it divides up into all the different colors of the rainbow, or when you see a rainbow, it's really, right, you're seeing all the different colors in the light spectrum. Really the cool thing about white light is that it's really a small spectrum of electromagnetic waves, and light are the ones that are the electromagnetic waves that are visible to the human eye. So there is see how we've got all these different types of electromagnetic waves, right? We've got gamma rays, X-rays on the left, and then longer wave signals like radio and broadcast bands on the right. Well, there's just a narrow band in the middle of these waves that the human eye is capable of seeing, and we perceive them as either white light or color. The interesting thing is that the different colors have different wavelengths. So red has the longest wavelength and violet has the shortest wavelength, and the other colors fall somewhere in between. Okay, so again, when you show all the lights together, all the different colors together, you get white light. And the way our eyes perceive color is that when white light bounces down on an object, the object will reflect the one color that it does not absorb. So the yellow lemon right there, white light, all the different colors of the spectrum hit the lemon. Because of the way the lemon is chemically constructed, the lemon will absorb every single color and bounce back the yellow light. And that is why we perceive the color as yellow, the lemon as yellow. So isn't that interesting? Actually, the one color we see is the one color the object is not. Yeah? Our eyes are such fascinating structures. So, again, getting my cheat sheet up. Okay. So, our eyes have both rod cells and cone cells. Cone cells are the cells that perceive color. So we have specific cones that perceive red light, green light, and blue light. And then we have rod cells that distinguish between darkness and light. And our eyes are so complex. We have 120 million rod cells and 6 million cone cells in our eyes. And interestingly, 60% of the color sensing cells, the cones, are red. 30% are green, and only 10% are blue sensing. And then the other interesting thing is, so if you look, the blue receptors are, the blue cones perceive light in the wavelength that is shown on the left, right? That left wave in this chart right here. So when the blue cones are activated, these two are really low, and that's why we perceive a certain object as blue. Interestingly, though, it's very complicated, much more than just one, one-to-one correspondence, right? So to perceive like red or orange or yellow, it depends on the stimulation of the red and green cones combined, right? So when we perceive something as primarily red, it's because the red cone is more stimulated, but the green cone will also be stimulated as well, which is why many of us have color variation in how we perceive things. Okay. Once we have absorbed all this information, right, what kinds of meaningfulness do these images send, right? So I started with red and created an example for you of all different referential meanings of red. Because, first of all, as I mentioned, we have a lot more red receptors in our eyes, so they hit us really hard. There are a lot of receptors to take in the red information, and because of that, and also because of the length of the wavelength, all kinds of studies have been shown to indicate all kinds of interesting biological effects that the perception of red has on our physiology. So the rate of how often we blink is increased when we see red. So they've done studies, for example, on different websites, one with a red background, one with a blue or purple background, and the colors don't seem that different, but people even perceive the passage of time as quicker when they're looking at the red background. It really affects heart rate increases, all kinds of things increase when we see red, right? And the other thing I think is so interesting about red is the very contradictory signals that it sends, right? Think about, if you go to the amazing Institute of Art here in Chicago, you'll see all these beautiful Madonnas, and they're often wearing red, right? Red can be a color of purity. The Pope wears red. But on the other hand, red is also the red light district, right? Red is stop. Red is the scarlet letter, illicit passion, right? Red is also, we think about the red states versus the blue states, but the communists are also red, right? So even the political spectrum, right? We're seeing red on one side and red on the other side. Red is the color of fire, and also the fire engines that put out the fire. It's the color of blood. It's the color of wine. Think about the incredibly different flavor signals that red sends. What are some of your favorite red flavors?
Strawberries.
Strawberries, yes. Cherry. Any meat eaters? I love that raw
Steak.
red meat. Yeah, steaks. Wine? Any red wine drinkers? Yeah? What are those red hots? Those cinnamony red hots? Yeah, there's so many different flavor signals that red sends, right? Yeah, so one color can send so many different signals, right? And you can see that given this kind of array of, our eyes being bombarded with all these colors all day, and then also all the referential meanings out there in the world, how do we figure out when these things should be protected, when colors should be protected as trademarks? So the other thing that I think is really cool about colors as trademarks, anybody have like big allegiance to a particular team? I know my husband's from Alabama. He hasn't lived in Alabama for a really long time, but let me just tell you, that allegiance runs deep. And the Crimson Tide, the color crimson, whatever, it's always going to be about Alabama for him, right? Even our team allegiances can be so deeply built. Our sports allegiances, our school allegiances, academic or otherwise, can be so deeply built around color. I grew up in Cleveland, so brown and orange was a thing. But they also, like the Red Cross, right? Donating blood and emergency aid, and no, you shouldn't drop a bomb here because this is a hospital, right? So many different symbols. The other reason why I put this slide together is I think that it's interesting that people are seeking trademark rights for things you wouldn't expect. Like, okay, we've all seen the red target symbol. But really, blue for pipe? Or did you ever think when you see red scaffolding that color might be protected as a trademark? It's actually a registered trademark. Cover of the Zagat's book. All of these are protected trademarks, registered. Okay, so to try to figure out whether or not consumers actually perceive colors as marks, first what we did is we asked them kind of some identifying information. Who are you? Where you live? How old are you? Male, female, that kind of thing. And we also then asked what their favorite color was. And it was a huge relief to know that the 1,000 people who answered, kindly agreed to take the time to answer this question, answered this in the way that other studies have, just very, very similar to what's been found. Other studies, interestingly, both here in the United States and abroad. We looked for studies in multiple countries and found Blue is the universal favorite, often followed by green, red, and violet. This is how it's sorted out. It's kind of interesting. Purple came out a little bit more prominently than we might have expected. We then sorted the favorite color data by gender, and you know, only 7% of women claim pink as their favorite color. That's important to know as a trademark lawyer, right? Blue was the universal favorite for everybody, but look at purple. Look at how 20% of women, purple is their favorite color, and 7% of that. So that was kind of interesting. So purple and pink, I think really, so here we've got, you know, the purple are the women, the green bars are the men, and you can see the percentages of how many selected each color as their favorite. Yeah, it's pretty interesting, right? One thing I think is very interesting about this data, though, is genders aren't so different, right? Differences, with, especially with purple and pink, and young men do, you know, the women who like pink a lot and purple like that, like the difference is made up for all the men who love the 42%. Okay. But then the next thing that we did in our survey is we asked the consumers to identify which color makes you happy. Which color do you associate with high quality? Which color do you associate with luxury? Because what could have happened is they could have just picked their favorite color for all of these, right? You're trying to figure out, okay, maybe if one color is your favorite, but is there a different color that maybe signals happiness, right? And look at yellow, right? Happiness is the green line. Look how high yellow is on the happiness bar. But very low in terms of purple, which is high quality, and yellow, which is luxury. Gold, super high. There's the gold bar, right, category 3 down. For luxury, very, you know, and some for high quality, very little for happiness. Interesting, right? Because yellow and gold are not so far apart. Anyway, we thought this was especially interesting because, you know, black is associated with high quality and luxury, not so much with happiness. So it seemed that it confirmed our belief that consumers do attribute different qualities to different colors, and those don't correspond necessarily with what their favorite color is.
But advertising and branding drives this, 100%.
Oh, tell me more.
Oh, 1,000%. Because of gold cards and black cards, this is not, you can't look at this in a vacuum.
Right.
I mean, I think yellow probably is the only organic result here, but this is the black and gold values, and maybe even to some extent blue because of American Express. This is absolutely driven by advertising and branding.
Fascinating.
Absolutely,
All right.
1,000,000%.
We need to talk after this. This is so
I'm
interesting.
happy to discuss it with you afterwards, and even green, well, the high quality isn't there because the American Express, you know, the basic card is green, but this is absolutely driven by advertising and marketing.
Fascinating. Fascinating. Tell me your name?
Stacy Calamaris.
Thank you, Stacy. That's awesome. I saw a hand up back there. Yeah?
I think this is also very American.
I also agree with that.
Interesting. Well, this we did not look for international comparisons, and that would be a very interesting thing to do. I
Because
appreciate
like red
that.
in one culture or black or white, like something that is marriage in one culture is funerary in another.
Yes, so we did look at that, and there's actually, so it's interesting, the surveys on that have really changed over time. So for example, in China, red was traditionally associated, and India too, with marriage, but because of, I guess, the westernization or maybe the universalization of fashion, there has been, we did find some data that shows that there is a bit more coming together cross-culturally on some of these issues.
And that's a lot, I'm sure, because of the internet and how we're all connected.
Right, exactly. So that's a fascinating trend as well.
So I don't entirely disagree with the advertising comment, but I don't entirely agree either. I think it's a chicken and egg thing. I think that the reason that advertising drives the association with, you know, gold cards and black cards and all those things is because people associate these values with these colors. I think studies were done before the colors were associated with credit cards and among other things. And now the advertising drives that. So I kind of think it's cyclical.
Yeah, and this, the other thing that's really important to to note here is that this is a very dynamic thing. As culture changes, as the different signals that we use change, the law and the United States Patent and Trademark Office have to respond. So what's happening with green is so interesting. Green, what does green now symbolize to everybody? Environmentally friendly. Well, interestingly, some of the data that John, this is not data we collected, but another study collected data on eco-friendliness of colors and found that actually people associate brown most prominently with eco-friendliness. But because we all perceive green as the eco-friendly color, right? Green this, green that, the U.S. Patent and Trademark Office now will not let you register a mark using the word green unless the product itself has some sort of eco-friendly quality.
Right, because it's misdescriptive.
Yeah, but color green, they have not. And the interesting thing about that is that a lot of data shows that colors send much stronger signals than words. So that is one of the interesting points that we're hoping to make through this article is that color can actually be more powerful than text, and therefore, if you're going to block the word green, you better think about the color green with products that are not eco-friendly.
I agree with the chicken and the egg analogy, and it's probably applicable to this as well. For yellow, what I think of for that is a smiley face.
Mm-hmm.
You know, I mean, Walmart does that. It's all over the place.
Deborah?
So that's initially what I would think.
Because we're recording this, if you're going to have interjections, can you just briefly summarize what's been said so that
Yes,
the mic
I
can see?
absolutely will. Actually, why don't we, I love the questions, I love the participation. I think we got them all. Let's keep scrolling through the data, and we're going to have a whole 30 minutes for more participation questions. But yes, from now on, I will to make sure we've got it on recording, repeat the questions. All right. So we wanted to, okay, after getting consumers in our survey to think a lot about color and different meanings color sends, we thought, all right, now it's time to ask about brands, because they've already got all these color thoughts in their head, and we asked people if their favorite brand is the favorite color. And look how many said yes, 63% said yes. We also asked if color was helpful to people in finding brands when they shop. And look on the right, 68% of people said yes, color is helpful. Helpful or very helpful. The dark blue below represents the 25% that said it was very helpful, and the 43% above that shows that to all people it was helpful, but some didn't say it was very helpful. Only 32% said no, it's not helpful at all. And then we sorted these by male and female, and as you can see, 74% of women say it's helpful compared to 61% of men. So I think just from our own personal experiences, we've probably all, you're looking for a product, you're in a hurry, you're in the grocery, maybe you do look for the squat orange bottle because you know your whisk detergent comes in it, right? That is an experience I think that, at least from our data, looks like it's pretty universal, that over 60% of men say that they do that when they're looking for comparable products in the store, they look at color, and women, it's almost 80%, right? So that we're looking for things in a shop, we really do look at color as just kind of a quick way to find something, pick it out, and keep moving. So this was really interesting. So I thought these numbers were going to be much lower. The question here was, how helpful is color when you're looking for brands online? And I thought this was going to be a lot lower because when I shop online, I'm always typing text into the dialog box, right? But apparently lots of people actually find color really helpful when they shop. If we ever did another follow-up survey, it would be really interesting to dive deeper into this question and find out how it's helping consumers. Okay. Now we're going to talk about the law. So there are barriers to getting trademarks registered that other marks don't face. And one of them is the functionality doctrine that is used for trade dress but not used for things like word marks. And the functionality doctrine basically says that if you are going to, if the feature is going to give you a competitive advantage because it makes the product cheaper, easier to manufacture, then you should not get a monopoly, right? So for example, my son, Ben, who kindly agreed to join us today, he's a violinist. right? And what color are violet bows?
Off-white. Sorry.
The hair is off-white.
Brown.
But the wood, the stick is brown, or if it's carbon fiber, it's going to be black, right? So nobody is going to be able to get a monopoly on the white for the hair of the bow, or brown and black for the stick, because it would make it more expensive for competitors to compete in that market, because they have to add some color in to cover up the natural material. Plus, we expect an orchestra to kind of imagine all the clothes to be brown, right? So there's an expectation in the industry, and therefore nobody is going to be able to get color in those colors in for violet bows. That would be prevented by the functionality doctrine. Interestingly, the first Supreme Court case to deal with this issue found that it was fine for the defendant to copy the plaintiff's product and the plaintiff's colors in their generic medicine. I don't know about you, but I do identify my pills by color. Like I look for that, my orange Advil. Very distinctive color and shape when I'm in my pills, right, in my little Ziploc bag when I travel. But they didn't find that here, and the color was not found to be protected. So it was really a question for a long time whether you really could protect color as a trademark. There was a circuit split until this case, Qualitex, was decided in 1995. I am the proud owner of one of these Qualitex industrial press pads. It's very big. Oh my God, you have one! How fabulous! Can you please come over to us? Qualitex? Yeah, somebody just feel free to stand up and bring it up here. That is so awesome. I thought about traveling with it. Thank you so much. Okay, yeah. I love it. Props from the audience. Okay, this is Qualitex green. What thoughts does this color evoke in your mind? Pea soup.
It's the new Sinex color.
It is like some really unpleasant things are coming to my mind when I look at this color, right? Like bad 70s design, all that. Okay, well, I don't think it was an accident though that this was the first case in which the Supreme Court held that color could be protected. Well, like really? So you're putting people at a competitive advantage and disadvantage if they can't use this, right? Anyway, this was the test that the court came up with, and it said that basically you cannot get color protected if it's essential to the use or purpose of the article, or if it affects the cost or quality. So the violin bow example is the cost or quality example. Essential to the use or purpose, well, nobody is going to get pink for strawberry ice cream because we all expect strawberry ice cream to be the color of what we expect the flavor to look like, right? Or if exclusive use of the feature would put competitors at a significant non-reputation related disadvantage. So here, if the advantage the color gives is reputation related, perhaps the Tiffany's box, then you can get the color protected. But if it gives you an advantage in some other way that isn't related to reputation, the functionality doctrine will block the applicant from getting the trademark. Okay, so for example, nobody's going to get a trademark in the red for Valentine's Day, right? Because it signals the meaning of that holiday, right? The colors of Santa Claus. Dippin' Dots tried to get the colors registered for its little round ice cream dots, and it failed because each color corresponded with the flavor. So the functionality doctrine blocked that as well. Okay, but the academics went crazy when this case was decided. Oh my God, trademark law has lost its way. They're going to let all these crazy things that shouldn't be trademarks ruin everything, and it's going to be a terrible situation. Way too much overprotection and very horrible anti-competitive case. All right, and in fact, this is what happened. So we looked at, John and I have gone through a ton of data to try to determine how many marks for color had been registered. And as you can see, in this circle, in this pie chart, registered trademarks going back more than 2 decades comprise over 70% of all marks. Most marks are just words or some combination of text and numbers. Some 24% are text and design, 3% are design. The percentage that are color only appear in the pie as purple, and that are designed and color appear in the pie as yellow, but there are so few of them, you can't even see them in the pie. Like the data doesn't even show up, even when my chart, I was really curious, when my chart was blown up this big, if you would see the sliver, you can't see it. It's indiscernible because the percentage of marks registered that have color in them are so tiny. 0.02% of all marks are color only, 0.04% are design and color.
Is that color only a single unitary color or one or more colors? Did you divide it
Our
up?
color only marks are marks that are only a single color and cover the entire surface, so there's no linear element. Okay? I'll show you examples in a minute. All right, so here's the other thing that's super interesting. If you look at all marks, so publication means that the United States Patent and Trademark Office said, yes, you can have this trademark. But not all of those become registered because some people file trademarks on an intent to use basis and then end up deciding not to use them. So I think the real measure of success that we should watch here is publication, which right here is the yellow bar. So supplemental registration means that basically the United States Patent and Trademark Office said, you know what, you can't have this because it just is incapable of signaling source right now. Maybe later you will become more distinctive and you'll get your mark, but not yet. So that's a rare thing. In all marks, 3% of the time. So text and all marks and text and design, they all look pretty similar. And when you're looking over here at text, design, and color, you can see that the pattern looks very similar to all marks, even though it's only a tiny percentage, right? Similarly, design, right? Remember that was a very small percentage from our pie chart, but now look when we add color into the mix, right? Suddenly the marks are much harder to register. Remember our publication was our big success rate. Look how much it drops. And one thing John and I discovered in the data is we need to clean up our data a little bit. It's actually lower than those numbers in here. We're working on and making it perfectly exact, but we think it's actually a little bit lower than even this chart reveals. So a big difference, much, much harder to register marks with color in them. Okay, here's a quick chart of the registration process. You file your application, the United States Patent and Trademark Office reviews it. If they like what they see, you get published, and then you go to registration unless you're an intent to use, where you have to file a statement of use. So it's often at this place that people decide not to pursue a mark, and that's why the publication and the registration rights are different. Most marks that have a problem after the application is filed have a problem at this point in time. 2/3 of all trademark applications get some sort of pushback from the United States Patent and Trademark Office where the government's saying, look, you need to fix this, you need to fix that, or we're not sure you really should get this, right? Very important to know for all the non-trademark lawyers in the room, another study that John and I did called Do Trademark Lawyers Matter shows that it matters a ton.
Right, because pro se skew that.
Pro se skew it, but also people who are lawyers but not experienced trademark lawyers do not have success similar to inexperienced pro se people. You've got to get a good trademark lawyer.
Correct.
Yeah, and for your trademark lawyers out there, great piece for your marketing agenda. Because we have great data how it really does, and you have so much more success if you have a lawyer that knows what they're doing with this. And it's tricky because pro se people, 40% of applications now are filed pro se. So a lot of people try this and then they screw it up and then they try to have a trademark lawyer fix it and then you have to start over. Okay, lots of advantages of what, this is basically why do people even want to get federal registration, and there's lots of reasons. I'm just going to highlight the few that are in bold. One is you get exclusive rights nationwide. You really get great notice and deterrent value, and once your mark becomes incontestable, a whole bunch of ways to challenge the mark just disappear. Plus, I think an underappreciated benefit of having a trademark registration is that the United States Patent and Trademark Office examiners, when other people come and try to register similar marks, they will block those applications for you. So it really, you get the USPTO in some way on your side, helping you a little to police least your mark and make sure confusingly similar ones don't register. Yes?
Just in terms of your data, you were saying that academics went crazy with politics being down. If you wanted to take another slice and be even more robust, you might want to look at letters of protest and oppositions and the trends for the types of marks.
Yes, that is a great idea.
Can you repeat that?
Yeah, the question is that we could look at letters of protests and oppositions and see how much of those are related to color marks.
Because it would also show how the marketplace is reacting to the concept of owning color.
Yes, that definitely is a great idea for a deeper dive. This really is a 10,000 feet above view, but I love that idea. Thank you so much. Okay, so let me show you the data that we have. I really love that idea though. So when you look at all applications, so our data goes from 1987 to 2017, so we got a lot of data. And the blue line at the bottom is the supplemental register. That's the one that's hardly ever used, right? The yellow line is publication. That's the good thing. That's what you want. You want the USPTO to say yes. And then many of the marks that publish will go like the purple line and actually get registered. I'm sorry, the green line is registration. The yellow line is publication. The purple line, of course, that's the biggest number. Those are all our applications. Now, you'll notice that right here, the yellow and the green lines are together. That's because that's before you could file intent to use application. So once the law changed, then you've got that differential that evolved. But look how low, as a general matter, how infrequently marks appear on the supplemental register. That's for descriptive marks that could never have, where you couldn't prove secondary meaning, and many of these marks do not ever become registered. Okay. Text, not surprisingly, the trend looks very much like all applications because most of the applications are for text marks. So I just popped those on the same page for you. Design only. So for design only, going back to your question about how we categorize things, we included in design only things like target but in the black and white form, things that were some sort of design, had no text, but didn't incorporate color. And then applications claiming design and color were things like the target, right? The red target signal that is a design the entire thing is really just red and white, but it also has a linear element, the design of the target. And you can see that once you add color in, things start to look very different, right? First of all, there are many, many fewer applications, so our data is not as robust. But look what happens to the supplemental register. Not only does the line raise above 0, but it looks very similar to the publication line, right? It's getting really close to the publication line. And then when we look at applications claiming a single color, we see that same type of pattern. We're getting, so here, interestingly, see this big spike right here? That's because that's when politics was decided, and suddenly people realized, oh wow, colors get registered. The Supreme Court said yes. There was a split in the circuits before then, but so that explains that spike. But you can see there's generally an upward trend where people are applying for color marks, not a ton, but more each year, and they're not having such a great rate of success. Many are winding up on the supplemental register. And by the way, when we talk about color marks, what we're talking about are colors that either cover the entire good or an entire portion of the good without a linear element, like the 2 examples I put down at the bottom of this slide. I thought you might be interested to know how many marks claim multiple colors versus just one, right? So we have over 2,400 that are seeking protection, that have sought protection for just one, and there's one out there that claimed protection for 10 colors. The other thing that we did that we thought would be interesting is just kind of cross the data from consumer preferences, remember the data on color favorites, to the number of marks that were registered in each color category. And we thought it was really interesting that 37% of people claim blue as their favorite color, but it's 20% of color marks. And I don't know, it seems to me there's a real opportunity with purple, right? A lot more people think of purple as their favorite color than are marks registered in the color purple. That's kind of interesting. Okay. Other thing that's really interesting is, so this is the color data in all the different goods and services categories, going by the different categories that the United States Patent and Trademark Office uses to classify marks. So there are different categories of goods and services along the bottom, and its percentages up to the top. So one thing that's kind of interesting is that you see a lot of the colors in all the different goods and services categories, right? There are a few colors like gray and even black that disappear at certain points, but we see red throughout, yellow throughout, green throughout, blue throughout. So this is being used for goods, for services, and across all kinds of different industries. We also put together this chart to give you a sense of which colors are being used. This is not by percentage. This is number of marks per category. So kind of interesting. In the hand tools area, no pink, right? Yeah. All right. Well, you have to have a mark registered to succeed with it in protecting it in litigation. Well, this is again my, husband's home state school. The colors claimed by the University of Alabama, and they do not have this trademark registered. These colors registered as a trademark. What do you think?
Harvard does.
Harvard does not, actually. They also claim protection, but they do not have it registered either. So, with color, functionality was a bar, but the other bar is secondary meaning. For the United States Patent and Trademark Office, you can't get something registered unless you can show you have secondary meaning, if it's colors, and that means you have to show virtually exclusive use in your field. Right? And Alabama is just one of the many schools that use red in their marks. So they are never, I'm going to go out there and predict they are never going to get a registration, but they win in litigation, which is really interesting. It's still a strong mark, and they litigated it successfully, not always successfully, but it's same with Harvard, right? They certainly have trademark rights in this as well, but because they're in the same field, providing educational services and sports and entertainment and all that, they neither, I predict, will ever succeed in getting just the colors registered. They could get them registered in connection with their names, or like that Alabama A, some symbol, but not color alone. So secondary meaning, so we thought it would be very interesting to take a look and see what kinds of obstacles these applications for color marks are confronting, and figure out why are so few of these getting through? Why is it so much harder to get a color mark registered than a word? And we thought, well, is it because of the functionality doctrine? Is it because it's merely decorative, right? Like if I try to get blue registered for a men's dress shirt, I'm not going to get that through, right? Because it's just the decoration on the shirt. It doesn't signal any source trademark meaning, right? Or is it secondary meaning? Is it like the University of Alabama Harvard situation where there's so many people out in the field, you can't prove exclusive use, even though people really do view it as a source identifier? Or is there a likelihood of confusion claim? You're trying to get it, but somebody else already has it and we don't get it through. So for this, we did look at office actions on failed, to the extent we could find office actions, and there weren't a ton of them, on failed color marks, to try to figure out what is blocking so many of these marks from getting through. And interestingly, especially, for you guys who are studying trademark law, and for you, Charles, going to be teaching a course in trademark law, we focus a lot on the functionality doctrine, but it's not doing most of the work here. Only 17% of the office actions that we found bumped things out for functionality, 25% for likelihood of confusion, and that's really interesting because overall, that's usually the most common reason why office actions are sent out by the United States Patent and Trademark Office. 37% is merely decorative. The color just looks like decoration, is not signaling source. 51% no secondary. So it's exactly that situation, the Alabama, the Harvard situation, where you can't prove that you're exclusive in your field. Well, we thought it was really interesting that Alabama can't get its colors registered, but we know it's won in district court. So we looked at all the litigated decisions we can find where they were litigating marks that were just color. And we didn't find a lot, but we found 19 district court decisions and 36 decisions decided by the Trademark Trial and Appeal Board. Interestingly, people have a win rate at the TTAB of 40% and a win rate in district court of 60%. And if you take 50% as kind of the general, like if it's a case that's going to litigation, there's probably good strong, there's data showing that there's probably it's about point flip or I should settle. So it's very interesting, 60% win rate in district court. It really almost makes you wonder, well, I don't even need a registration, right? Especially since if you try to get it and don't get it, that might hurt you later in litigation. All right, and that is the end of my slides. So I think I hit it right on the nose for leaving us 30 minutes for questions.
Perfect.
Go back to one of the
Sometimes you've got to warm the audience up, but this audience is obviously all set and ready to go.
Oh yeah, we're ready up here.
I'll just move this over. If you don't
Oh,
mind.
I'm so sorry.
That's okay. All right, so as I said, students are the center of what we do. So I invited students to submit questions for Professor Gerhardt, and we'll ask some of these questions first, but the rest of you should start thinking about your questions or comments if you have them. One question focuses on the emotional impact of colors. And it's one thing to grant trademark protection as an indication of source on the color, but in doing so, are you inadvertently also granting a monopoly over the ability of competitors to use colors to achieve the kind of emotional impact that you discussed in your study?
I think it's definitely a concern. But our eyes are capable of perceiving millions of colors, and I think there are tons and tons and tons of colors available to so many different people, and especially in a situation where you're talking about a competitive field, let's say like fast food, nobody's ever going to get red or yellow because it's just too ubiquitous in the marketplace. I think that it might possibly be a concern, especially for new technologies, because it would be easier to get the color mark sooner, but again, you do have to establish secondary meaning, so you would have to use it for a while. And the other kind of interesting thing about color marks is that if you can ever prove they're functional, so even if it becomes incontestable, the functionality doctrine always makes these marks vulnerable. So if you can show, so for example, I believe somebody has orange, the color orange registered for earplugs that can be worn in water. But if you think about the color wheel, blue is opposite of orange. So orange is the color most likely to be seen in blue water. So I wonder if you could make a claim that orange in that situation serves a functional purpose of, if you're a kid and you've got an earplug in and you drop it at the bottom of the pool, orange is going to be the easiest color to find, right? So maybe the functionality doctrine in some cases could be very helpful to people in knocking these out. Similarly, you asked about the emotional impact, like anything having to do with love or passion, it's going to be very hard to get red protected, right? So to the extent that a color is associated with a particular shade of a color is associated with a particular meaning, it becomes harder, I think, to get it registered because of the functionality.
Thanks. The second question relates to this theoretical idea of an inverted U shape. And the idea of giving more protection is we are not at the peak of that inverted U. And so by giving trademark owners, in this case, more protection or broader protection even in the spectrum of colors, means that you are actually promoting the kind of policies that intellectual property rights should promote: innovation, creativity, commerce, etc. So in the regard to colors, should we be giving trademark applicants a broader swath of protection, or do you think we're giving too much protection and really should be cutting back? And this goes to where you see where we are on this inverted U.
Well, if you're worried about clutter, about anti-competitive effects, I would worry a lot more about text. There are millions and millions of textual marks registered and not nearly so many color marks. So the field really right now is wide open. Yes, you will face barriers for secondary meaning, functionality, whether your use is merely decorative, but you actually are using color as a mark, and the field is wide open right now. And it is one of the interesting takeaways from this project. It's very interesting to us how few color marks were out there and had been registered. So I think, I mean, there's so many millions of colors, all conveying lots of meaning, and it's not unusual. So for example, we live in North Carolina, and Duke and UNC had very different colors of blue registered. UNC is like sky blue, and Duke is blue devil, like more of a royal blue. We actually love blue in these slides, ironically. And those are not very similar colors. They're both called blue, but UNC actually does have its Tar Heel blue registered. Yeah, at least with respect to the basketball uniforms.
I see you hand that. One more question, and then we'll get to the audience. So this question relates to gender, and one of many studies show that men and women perceive color differently. If women actually perceive color with more sensitivity in the spectrum than men do, which is why when husbands ask their wives, is this what color is this, and you get all sorts of more fine-tuned descriptions, whereas most men would say this is blue or this is green, and it's much more horse green. So when it comes to the idea of likelihood of confusion, what consumer perception is, how does that relate into trademarks over colors?
Well, okay, so that's a really interesting question. And even just, John and I actually paused before we even asked the question about gender, because now there's so much fluidity, and people don't identify necessarily binary as a gender. And I think one of the interesting takeaways here, except for the differences that we saw in this slide, we actually didn't, at least in our survey, we did not see much difference by gender. In fact, we had sorted this chart, happiness, high quality, and luxury by gender perceptions, at least with respect to meaning. And this gets back to the point I think a couple of our audience members were making about the cultural meaning of these colors. The charts were so boring because there was basically no discernible difference in the genders, at least between the genders in these types of signals. So we thought perhaps gender might raise some more interesting differences than it did. What I think one thing it did, there was definitely a noticeable difference in the level of helpfulness when you shop. Of course, one thing I was thinking about as I was preparing to talk here today is I wonder, we probably should look at some data on who does most of the shopping, right? Because if men don't do as much of the shopping, well, of course they're not relying on color. When they shop, they do it less frequently. You know what I mean? So I think we could probably dive deeper into this. But and in the literature that I looked at about embodied meaning, it did not. There is more color blindness among men than among women, but it is still such a teeny fraction of the population that I think biologically our eyes are very similar. Yeah.
So, with sensitivity to the gender fluidity comment you said, just as a stereotype, guys, you don't have that excuse that you thought you did.
You're perfectly capable of, yeah.
I saw a hand back there. Yes, name and affiliation, and then you can ask the question. Yeah.
Van Economo, IPLaw. I have a question about your color data. Is it all related to single color registrations, or is it combination?
Okay, let me repeat the question.
Yeah.
So why don't you repeat the question?
Okay, so whether the data was related to single colors or multiple colors, and let me show you. Could be a little bit of both. So in the design and color data, it's all colors. And applications claiming a single color, these are the applications like this that actually claim just one color for the entire good. Yeah. We wanted to see if adding a linear element made a difference and if adding text made a difference, and it turns out each of those things, each layer of distinctiveness by design and then by text makes them more likely to register. But this data is for stuff like this, that it's all one color and all over the entire surface of the good or a portion of the good.
Yeah, see your hand over there. Name and affiliation.
Lamar, Jon Marshall. So I have two questions. The first one, what is that?
Oh my goodness, I'm so sorry. Okay, this is a baby Qualitex press pad, right? So Qualitex is the Supreme Court case that we talked about. It was the first, it was a Supreme Court decision that was first to recognize that color alone could be registered as a trademark, and color in the sense that it covered the entire surface of the goods, not in connection with a particular design, like a red and white target. What's interesting, actually, so when John and I first, I'll share with you just a little bit of interesting background about doing research on this type of thing. So when John and I first tried to discern how many color marks are there, we came up with less than 100, and this mark was not on the list. And we're like, how is that possible? Well, it turns out the way the USPTO codes the data didn't pick this up because this actually is registered as a design mark. So we've had to go through, and we're still actually with some of the most recent data going through the project and really figuring out, because it was the design was basically the shape of the ironing board, which is much bigger because these are for industrial, like dry cleaners and stuff like that. And one other thing that's kind of interesting to think about with color is for, cross-culturally, or if you have a population with literacy issues, I mean, this can really be quite helpful.
Yeah, and the second question, can the color ever be a trademark for a fashion item?
Yeah, the shoes, right? Oh, I'm sorry, I was supposed to repeat the question. Yes, so see the undersole of the shoes, right? In that situation where it's being used for not just for decorative purposes, but more primarily to signal source, it can be.
Can you argue that it's functional instead of?
And they certainly did. They certainly did. Yeah. This was a litigated case. I'm happy to share with you more information about that. It was really an interesting case because it was litigated against Yves Saint Laurent, and the shoe that actually they sued against was a solid red shoe, which really was kind of crazy because the undersole was red to match the rest of the shoe, not really, they could have sued Payless before, now that I understand they're going out of business, because, there's so many knockoffs, but instead they sued another luxury brand, and the court actually ended up splitting the baby by saying, yeah, we're not going to take away your trademark, because they recognized this had a ton of secondary meaning, but we're going to narrow the registration to be limited only to the red undersole when it was in contrast with some other color. So the defendant really didn't lose because they got to continue selling their red shoe, but the plaintiff got to keep their mark too. It just was a little bit narrow. So it was a real split the baby kind of thing.
What is your head? Lamar, I think we've got to move on. Yeah.
Yeah, so is the mere use of color just to attract people to the product in the first place considered functionality? Because if it is, it almost seems like anytime you would use colors that pop or colors in like any sort of interesting way that isn't sort of applied in like just a neutral sort of way, it seems like pretty much any trademark on a color scheme would pretty much be shot down for functionality almost every single time.
Yeah, well, so the question is basically how, because color always attracts attention, how do you figure out when color can actually have trademark meaning? Is that a fair summary?
Yeah. I guess more like, is the mere use of color to attract people to your product considered functionality? I guess is what I'm
okay,
trying
is
to
the mere use of color to attract people to a product enough to mean that the functionality doctrine will permit your use?
Yeah.
Okay. Well, it's really the $10,000 question, right? So if you're using, brown or black for violin bows, you're using it because you're using black to signal this is made of carbon fiber, or brown because it's made of this special wood. So the color in that case is used to signal not the reputation, but the actual material that the thing is constructed of, and nobody can get a competitive advantage in this. So this functionality doctrine is designed to protect people so they can use colors like that. Now, in a situation like this, yeah, the defendant used the same colors as the plaintiff to attract attention, but I don't really think they were using it because they wanted to look like the plaintiff's pills, right? And that to me, I mean, they won this, but that to me is a trademark, right? Because they could have told people, look, it's the same, it's generic, it's the same formulation, just this is our version of it. Yeah. So it depends on why you want to attract attention. If you want to attract attention because you want to trade off the reputation of the senior user, then there's a trademark issue. If you're using it because you want to signal to consumers, this is what the product's made of, this is a beautiful shirt, so that merely decorative reason for not getting a trademark is because, oh, it's just really pretty, right?
Did I see a hand behind? Yeah.
Paula Krasny, I'm a total trademark geek.
I love that. Wait, could you just say your name one more time?
Paula Krasny, I'm a partner at Vantablack.
All right, we need to trade cards.
Have you thought about how to look at your data and try to reconcile the difficult doctrine of aesthetic functionality?
Well, have we thought about looking at our data for reconciling the doctrine of aesthetic?
And it's very difficult, it's not decided.
Yeah.
It's still.
Yeah. So this is how I think of aesthetic functionality, and we should probably make sure we're on the same page. So the functionality doctrine, as you can see up here, has 3 prongs. The first 2 I think of as really utilitarian or kind of original inwood functionality, right? The inwood case, the one about the pills I just showed, where that apply often, like if you have a patent or something, and you've created something in a specific design, like one of the cases the Supreme Court decided was traffics, where there was a 2-spring design that helped those signs, like the men working signs, right, on the road stand up better. So the question was, could they have a trademark in that 2-spring design? And the court said no, because you have to see the 2 springs to understand how the invention works. Yes, you had a patent on it, but the patent proves it was more useful, and therefore it's really great evidence that it fails the functionality test on the first 2 prongs, right? Color generally is something that we think about in the 3rd prong, right? Generally, but not always. So, for example, with the Dippin' Dots, right? I think it's pretty essential to the use of ice creams in those flavors to be the colors that consumers associate with the flavor. So I think that the Dippin' Dots, even though it's color, would fail that first prong. But normally when we think of color, we think, and the aesthetic functionality doctrine, we think of the 3rd prong, right? And this was a prong that the Supreme Court developed particularly in the context of color, and this press pad to say, okay, you don't need that color green to make a press pad, and it's actually more expensive to add a color, so it's not going to fail the first prongs. And competitors need to hide stains, so they need to use some color, but it's not going to put that at a competitive disadvantage to use another color. To the extent the others want to use green, it's because everybody knows that politics is the leader in the market, right? So it failed what we call the aesthetic functionality test, that 3rd prong politics. I think it's a really interesting question because we really don't spend that much time thinking about when you fail the functionality test, which prong you fail. And I think the Dippin' Dots would be a really interesting example of just failing the normal functionality test, and politics being an example of really where it's aesthetically functional. But Yeah, there aren't a ton of these decided, so it actually would not be a hard question for us to ask and answer in our article. I will definitely, I know my
And there's
co-authors.
some really wonky decisions out there where they
Yeah.
say you did the coolest color combination, and the marketplace loves it, it's aesthetically functional.
Right,
But
exactly.
if you were the first, you know, it's a tough one.
It's a really, really tough question. Yeah. One of those that matters to
It's one that's bothered me my whole career.
Well, we definitely have to talk more about this. That sounds so interesting.
I see a hand back there. Yep.
Hi, my name is Untitled Chapter. I'm an examiner with the U.S. Patent and Trademark Office. Patents only.
On patent side, awesome. You have you have a colleague in the room. On the trademark side.
Do you have comparative data with other national trademark offices to compare how the United States values color as a trademarkable entity as opposed to Canada or England or?
All right, so
or,
here's a great
France?
question that I want to make sure my co-author hears. Do we have comparative data from other countries to see how the U.S. protects colors versus other countries? We've not looked at that yet, but I think you have just identified our next project. I think that's a great idea. It would be really interesting to sort this data against that and see if U.S. is protecting it more or less. John, have you seen anything on that?
No, he's shaking his
He's
head.
shaking his head. Okay, yeah, I can't hear it, but I see him shake his head.
And I see a hand back there.
Until they have that data.
Yeah, I'm sure they will. Yeah, if you're a trademark geek and you're not a member of the of Intel, you should join. It is the most awesome organization.
And talk to Joe Marie over there.
Yes.
Shout out to Joe Marie, who is our advisory board member.
Pantone color number 1837 is Tiffany blue. Does that help them or hurt them in a functionality attack?
Well, it help. So another thing we looked at was. Oh, I'm sorry. Does having the Pantone number, the specific Pantone number referenced in the trademark registration help them? So there are different. I'm sorry. Tell me the
It's
question.
not referenced in the trademark registration.
Oh, but it is a particular.
It is assigned
Okay.
by Pantone
Yeah.
to them.
Right. Okay. So Pantone has assigned particular colors. This particular robin's egg blue to Tiffany's, and Coca-Cola has a particular shade of red. And I understand the newspaper in Atlanta is not permitted to use that shade of red on anything except a Coca-Cola ad, right? So some of these big trademark owners can get super aggressive about policing their particular shade of a particular color. And I think it helps them because it makes sure, to the extent possible, that when we see that color is relatively uniform across different materials, across different platforms. It is not an easy thing to do to make that color look the same on the screen compared to a piece of cardboard, compared to a piece of cloth, right? So it is something that the trademark owners who are serious about their marks spend a lot of time and money on. One thing that is kind of interesting in registrations is sometimes you'll just see blue, sometimes you'll see robin's egg blue, and sometimes you will actually see people claim a particular Pantone color as their trademark.
It's a private deal between Tiffany and Pantone for that blue, and that blue is not publicly available.
So anybody who wanted to print a catalog in that color that Pantone would not permit, that is fascinating.
Well, according to what I'm reading now, it's because I'm thinking Tiffany must have licensed it, there's got to be some deal. And it's not a publicly, so if you were to go and be like a painter or something, it's
And
a
you went
private.
by, wow, that is fascinating. Thank you. So, okay, so just to make sure everybody heard that Pantone and Tiffany have a private deal which gives Tiffany exclusive rights to use of that
It's
color.
a private custom color.
Private custom color, and I bet you they're not the only one. I bet Coca-Cola has an arrangement like that with their shade of red. Really, I'm so glad you brought that up. That's something we should definitely mention in the piece.
Other questions?
Any other questions? You guys are amazing. I'm so grateful for all this really terrific sensitive feedback.
You've got one question over there.
That's a question that I was going to ask earlier. but
Name and affiliation, please.
Steve Noel, Ship Harden. regarding shading, because I really do think I can identify so-called Alabama red compared to, say, Wisconsin red.
Yes.
But I couldn't distinguish between Wisconsin red and Nebraska red, for example. And that was going to be my question when they filed their application, or any of these people that are losing on color. Do they just write the word red? You mentioned some word descriptions or shading, but could you actually identify a Pantone number in your application?
Yes, and people do that.
And where does that get you?
So the question is, can you, in applying for a trademark, can you, if you want to seek registration for a color and you want to differentiate yourself from a crowded field, can you use a particular Pantone color to be very specific and maybe even narrow the field of what you're applying for? And the answer to that is yes, and we do see Pantone referenced in the description of design marks, you know, not super frequently, but there are some in the data. But in a situation like, you know, Nebraska and Harvard and Alabama, I don't think it's going to help them very much, because the standard for trademark registration and whether you're likely to be confused with other marks is not identicality, it's likelihood of confusion, and those shades of red are so close that you may be able to discern, but I would guess that that a lot of people could. Or they're close enough that even if they could discern, if you looked at one of them, one could be confused.
All right,
So
just real quick follow-up. If you are in that situation, can you then resort to trade dress instead of trademark registration?
Well, so you really, the question is, if you're in that situation, can you resort to trade dress? Well, color is a type of trade dress, but you of course could have trade dress that includes more elements than simply color. But don't forget, you don't have to have federal registration necessarily to have protectable trademark rights. They're common law rights, and often they can be national in scope, just like a federally registered mark if you're perceived across the nation. The problem is with a lot of the university color marks is that so many schools use similar colors for the same goods and services.
So I see David Applegate excitedly wanting to jump in. Name and affiliation.
Thank you, Professor Lim. David Applegate with Williams, Montgomery, and John, and sometime adjunct professor here at John Marshall. Let me help the speaker, the gentleman from SHIP, and others of you out a little bit here, bringing 50 years of college football experience. I can tell you that Harvard and Alabama, like Indiana, are all crimson. Nebraska and Rutgers are scarlet. Wisconsin and Stanford are cardinal red, and finally Oklahoma is blue. And you should never confuse any of those colors. Particularly if you go to see any of those teams play each other.
Got it. All right. Well, I tried to, I don't know, you're gonna have to tell me where I need to correct my slides, but I think these are the ones that consider themselves crimson, and these are the ones that I found that look pretty close to crimson.
Well, the second from the bottom, far left, the bottom far left are both scarlet.
Okay.
If you go to the right of the N to the S, that is cardinal. And if you drop down to the bottom right, Wisconsin, and I'm sorry, the bottom second from the right and bottom right are both cardinal.
Got it. All right.
And Iowa State up there is cardinal.
All right. So I've got lots of cardinal red here, but at least am I good on my crimson?
No, no.
All right.
I see a hand over there.
Yes, Brandon McKay,
Hi, Brandon.
student here at John Marshall 2L. I wanted to address the Pantone question, because when you select and include a Pantone number in your actual application, you're kind of walking this line, right, between disclaiming other shades just one shade over and one shade the other way, whereas if you were to leave out the Pantone, you are less likely to get the registration. So it's a matter of will I get the registration versus how narrow am I making my rights now, right?
Yes. Right. So and you know, why claim color? So the question is, the more narrow you claim your trademark in your application, the narrower your registration is. So why would you ever pick a particular Pantone color? I think it's if you've got a field that's kind of crowded and you really want to sneak in, you're going to have to be pretty narrow. But you know, I think maybe one of the takeaways here is why apply for color at all? If you have a great design, maybe maybe you just want to file for your design, and then you can use it in any color you want, right? But yet we know that color, some of the data I probably could have spent more time on in this talk, shows that color has a particularly strong effect on the human brain. And so that is why I think there's a lot of room for color marks to be asserted that aren't so, I guess you just kind of have to do that balance. And the way a lot of big companies, like for example Target, do it, they get them both, right? They get the Target design in black and white, they get it with the word, and they get, boom, just the Target design in black and white and the Target design in red and white.
Right, thanks. You have time for maybe one more question? No? Okay, Lama.
So-
See, you're standing between everybody and coffee and cookies. No pressure. Just saying.
And we know you're eager to get to that. But we had another question. I'm glad we got a chance to circle
Go ahead,
back.
I'm just teasing.
So color is social projective because, say, like you said, light affects color in so many ways. So I think, like you said, you have one Pantone, but what if the light reflects it a different way and change that color? Are you not under trademark protection now?
Yeah. So that's such a great question, and it was raised very strongly
What's the
in the
question?
I'm sorry. I'm failing my repeat the question metric here. Okay. So the question is, well, colors look different in different shades of light, right? So how could you possibly have protection for something that is so variable depending on how you look at it? Well, that question was raised very, very strongly in the politics case by the defendant. And the interesting thing about color is that if you turn off the lights, you don't see color at all, right? And so we talked earlier about how our perception of color is completely a function of light, but the truth is, if you turn off the lights, you don't see words either, right? And the court basically found that it was not so inconsistent. Making decisions about whether two colors are similar is not so inconsistent with whether two words are similar. That sometimes you have to make courts have to make very tough calls, and the USPTO about words, they can do it with colors as well.
All right, with that, please join me in thanking Professor Deborah Gerhardt.